What I want to do is, first of all, to take you a bit to the coalface, to Southwark Crown Court, and tell you a bit about what's been happening there. And then I want to give you what I think is a steer for the future for the prosecution of this type of offence. You heard me described a little bit now. I've prosecuted so far 2 particular cases for the FSA. Their first case, which resulted in convictions, and also the King-McFall-Rimington case, which resulted in acquittals. I am going to talk to you a little bit about those. But as we start, just by way of background, what I've called the wilderness years, because the FSA had its powers for a very long time, for almost 10 years, before it actually got them out of the cupboard. Why was that? Did they not have enough to do? No, that wasn't the reason. Historically, they were very, very difficult cases to prove. And I'm certainly not going to give you a law lecture this morning. You'll be, I hope, delighted to hear. But it is a hard offence to prove. You have to prove that the defendant had inside information and knew it was inside information. That is, unpublished, price-sensitive information. Moreover, he has to have it from an inside source and know that he has it from an inside source. So it is quite deliberately a very, very high hurdle. And most of the cases will depend on circumstantial evidence. That is, inviting the jury to put the bits of the jigsaw together. Well, things did change, and along came, in particular, Margaret Cole, head of enforcement, and who said many times to the press that the FSA now has a policy of credible deterrence. So picking up on what Martin said just now, don't do it in London either. How did it all begin? Well, the first case which happened to come before the courts, which I prosecuted, was the case of McCoyd and Melbourne. Christopher McCoyd was an in-house solicitor at a company called TTP, and Melbourne was his father-in-law. TTP was going to be taken over by Motorola, and Melbourne made some quite astonishingly timely trades. Prosecution's case was it was about as basic as it could be. His son-in-law had tipped him off, they bought the shares and split up the money. A very, very straightforward case. It just happened to be the first one that came before the courts. And that of itself led to some quite interesting argument. Early on, before the trial began, as part of the disclosure arguments, one of the defence points was, well, hang on, is this fair at all? You haven't done anything for 10 years. Why me? Lots of others have just been dealt with down the regulatory route. Why should we be prosecuted? Now, of course, the fallacy of that argument ultimately is, well, that means nobody gets prosecuted because somebody's got to be first. And the court was not attracted by that argument, and the trial went ahead. Both the defendants gave evidence, and they were both convicted. McCoyd went to prison for 8 months. His father-in-law, who was very much older, received a suspended sentence. McCoyd appealed against that sentence, and the Lord Chief Justice decided to hear the case in order to give some guidelines about insider dealing. And I'm certainly not going to read all that out, but what he's said was quite instructive. The Lord Chief said the principles of confidentiality and trust, which are essential to the operations of the commercial world, are betrayed by insider dealing, and public confidence in the integrity of the system, which is essential to its proper function, is undermined by market abuse. And then this, which really did give the FSA a powerful steer, and I think it has done with government as well. He said, if there ever was a feeling that insider dealing was a matter to be covered by regulation, that impression should be rapidly dissipated. The message must be clear. When it is done deliberately, insider dealing is a species of fraud. It is cheating, and went on to say that prosecution was entirely appropriate. one of the grounds of appeal against sentence was back to the, well, it's all rather unfair. I'm the first one. In the past, lots of people would have just been dealt with down the regulatory line. The Court of Appeal were not at all attracted by that argument and said it may well be in the past other people have been very fortunate. But you're a solicitor, you must have known perfectly well it was a crime. Prison was right. In fact, they went further, and although of course didn't increase the sentence, actually said the sentence of 8 months was too low and it should have been 12 months. And subsequent cases have shown that in almost every case where someone is convicted of insider dealing, they do go straight to prison. So that was the first case. What's been happening since? McFall, Remington and King, which I prosecuted and I'll say a little about. Uberoy, the dentist and his son who was working inside, and Culvert, which you've heard about already. As you were told earlier by Paul, the allegation in the McFall, Remington and King case was that King had given inside information to his friend McFall, who in turn had passed it on to Remington. Well, as it turned out, the case was something of a roller coaster. As you may know, at the end of the prosecution case, the defence can submit to the judge that there is no case to answer, that no reasonable jury properly directed could convict. They made that submission, and the core of that submission was the prosecution must prove that nobody else could have even been in a position to give inside information to McFall. We argued that that's much too wide. That's proving a negative. We have to prove it was King. We don't have to prove that no one else in the world could have done it. The judge disagreed with me and stopped the case. But nowadays, the law permits the prosecution to appeal against that, what's called a terminating ruling. And it's almost quite dramatic when it happens, because the jury are told nothing. The whole case goes on hold. They're simply told, members of the jury, you're having a week off now, and of course there's blanket, there can be no reporting. And so we went to the Court of Appeal, and the test for me to overturn the judge's ruling is a very high one. I had to demonstrate that he had reached a decision which no reasonable judge could have reached. It meant that one of us had to be wrong. And the Court of Appeal looked at this very carefully. They looked at how the judge had ordered it, that nobody else could have been in a position to provide the information, and said, was that the right question? They agreed with me that the judge had got it completely wrong. They said, given that the way the prosecution was putting its case at this stage, the proper question for the judge was whether a reasonable jury properly directed could be sure, in view of what McFall did, that he had inside information from King. Now, the consequence of that was to make the elements of the offence quite clear. If the law in fact was, as the judge at Southwark had ruled, namely that every prosecution for insider dealing, you've got to prove that nobody else could even have been in a position to pass out that information, the hurdle would be almost impossibly high. Well, the Court of Appeal said that was not the test. The trial resumed, and as you've heard, in the event, the jury were not satisfied so that they were sure that all the elements of the offence were made out, and the 3 defendants were acquitted.